Hey everyone, Dan McKenzie here with McKenzie Law Firm. We are an estate planning, estate administration, and small business counsel law firm located in the Denver area, Colorado. I wanted to make a video today explaining a concept that a number of our clients definitely find to be confusing both on the planning side and on the administration side, and that is the difference between what are sometimes called the marital and the family trusts. And one point of confusion about these is that they go by different names depending on your attorney's preference. But you might hear the term Q-tip trust. That's what I just used to refer to the marital trust. You might hear credit shelter trust, bypass trust. These are versions of what I just call the family trust. And then within each of these types of trusts, there's a wide variety of possibilities for how these trusts get used and the terms of each. So it is a confusing topic, but there are some general concepts that I thought might be helpful to explain today, and so I thought I'd just take a few minutes here to lay this out for you so you can see how this works. And the way this usually comes up is through a revocable living trust. And so lots of people set up revocable living trusts. The primary purpose of revocable living trusts is usually to avoid probate. And so most people are just thinking of this trust as this thing out there. I've got it, it controls the administration of my estate, and then my family gets my assets, and there's no real process there. And that's not entirely accurate. Usually there is some process, and there are a few different options, and these things go through a few different phases after someone passes away. So I just want to lay that out for you and show you how these typically work. And so I've got this slide here that will demonstrate. We start off with the revocable living trust. Like I said, this is kind of the most common version of trust that you'll encounter out there. You might have one yourself. A revocable living trust is just an arrangement that you set up where you are retitling your assets to yourself, but not as yourself, as trustee of your trust. And so the reason that people do this is because it makes it easy for them to say, okay, once I can't administer this trust anymore, here's who's going to step in and be my trustee for me. And because your assets are no longer titled to you in your personal name, no probate is needed, because whatever is going on with you, whether you're in some sort of incapacity situation or you've passed away, the owner of your assets is your trust, and it is alive and well. And so we start there, and most people get that concept. Then what happens is, of course, eventually that person passes away. The person who set up the trust and created the instructions, put all the stuff in there, had it, owned the stuff originally, created this trust, retitled that stuff to the trust. That person passes away, and kind of the whole purpose of this really is to make this process a little bit simpler. But like I said, there can be a little bit more going on here than most people realize. And where this frequently gets a little bit confusing is when we have a spouse, which obviously a lot of people do. They pass away with a spouse. And so the first thing we got to take care of is what I refer to as the administrative period. And the administrative period just means gathering assets, collecting any money that you're owed from an insurance policy, from somebody who owed the trust maker money, from refunds from taxes, closing accounts and collecting funds, selling assets and collecting funds, all that kind of stuff, and then identifying creditors, making sure we know who was owed money by the trust maker. Is it a valid debt that survived their death? Do we have to pay off a mortgage? Do we have to file a final tax return? Usually the answer is yes. And so that is very important, and making sure that that happens. And again, a lot of times people assume if their spouse passed away and they had a revocable living trust, and they assume, well, I'm the beneficiary of that trust, so I don't really need to do anything at this point, right? It just continues on. And so no, usually you should look into whether there are a few administrative things to do first. And then the next phase after that is, okay, now what happens once that administrative period is complete? And at that point, we have a couple of possibilities. And what frequently happens in a lot of trusts, especially older trusts, because this used to be very necessary for a lot of people for tax avoidance reasons that I'll get into in a minute, or tax deferral reasons, I should say, is that the trust gets set up in a way that now it breaks into two pieces potentially. And one piece is the family trust, and the other piece is the marital trust. And The reason for this is, again, usually tax deferral or protection of assets in a blended family situation. And so you might wonder, well, why would I need a family trust and a marital trust when my spouse is in the family, right? Aren't they the beneficiary of the family trust? And the answer to that is usually yes. But the point of the family trust is to put all this stuff in this bucket that usually the spouse is the trustee of the assets that are in that family trust. The family trust frequently says the spouse is the primary or only beneficiary of this trust anyway, but there are very few rules about how the spouse has to use the money. They don't have to receive income necessarily from that. Other beneficiaries, other kids, either the kids you had with the spouse or kids from previous relationships could be beneficiaries of that trust. And again, it's just used without a lot of requirements for specifically when money has to be removed. Now, the issue there is that when you leave money to anyone other than a spouse, we have to consider whether there's an estate tax due because your spouse is the only person who can defer that, right? So if you leave money to your kids, for example, and it's more money than you're allowed to leave without actually filing a gift tax return, we need to know that. And so since kids or other people could be beneficiaries of this trust, or because this trust doesn't necessarily have to be made available to the spouse, the estate tax is an issue. If you are fortunate enough, and a lot of people don't think of paying taxes as something that happens to the fortunate, but in this case, it is a sign that you've done something right in your life, I think. If you have an estate tax issue, and right now, as I'm recording this, it's 2020, and the estate tax is quite high. Each individual is allowed to give away more than $11 million. You are allowed to use your spouse's unused gifts, and you go out and claim those and add those to yours, so potentially spouses can give away $22 million. And that's another thing, by the way, that is not automatic. Just because your spouse passed away and didn't necessarily give any gifts to anybody doesn't mean you can give away $22 million. An estate tax return needs to be filed, and the surviving spouse does need to actually take affirmative steps to claim that unused portion. So just FYI there, that is another thing that needs to be thought of when your spouse passes away. But if you have more money than you are allowed to give away without filing a gift tax return, you will put that money probably in the marital trust. And the marital trust is limited to just the spouse. It is not for anyone else. And money inside of a marital trust does not get taxed. There is not an estate tax due at that point. And the reason for this is, of course, you can give your spouse as much as you want. You're not limited to the $11 million. You can give $1 billion to your spouse, and again, they're not going to pay estate taxes at that point. To make sure that people do not give money to spouses in trust that the spouse can't actually use. So you can imagine people doing that. It's like, well, okay, I'll give you money, spouse. I don't actually like you, or I don't like your kids, so I'm going to actually just put it in a trust and say you don't actually get to receive anything from that trust. Well, in the IRS's eyes, that's not actually a gift to the spouse, as you can imagine. So they've got a number of rules in place where you do have to make the income available at least on an annual basis, and there's a couple other things that are required for a marital trust to qualify for tax deferral. And so a lot of times what we see is, again, family trusts get filled up first. Marital trusts are there just as a tax deferral purpose. But again, there can be other reasons to put marital trusts in place to protect assets for in a blended family situation. And then once, eventually, of course, the surviving spouse passes away too. And now at this point is when these assets that are in these two trusts usually are brought back together and distributed to descendants of the original trust maker. So ultimately, that there's another path down there afterwards. But point being that the marital trust and the family trust, you might see these, and a lot of times it's something that's on paper, really. I mean, the surviving spouse, like I say, is frequently the trustee of both trusts. They're really in control of both buckets. But there are a few things that you do have to do to make sure that this gets handled correctly. There might be some retitling that has to be done to make sure that everybody knows, which asset is where. And the surviving spouse, if they are the trustee or whoever the trustee is, really needs to make sure that they kind of segregate out those assets, that they keep track of where money comes in and goes out of these trusts, that there's a good accounting each year made of these trusts, so that, because primarily the purpose here is to protect assets for the descendants, right? We want to make sure that they're not eaten up by unnecessary taxes or spent entirely on a spouse, or that spouse, if that spouse has kids either from previous marriages or later marriages, or gets remarried to someone else, that whatever they end up doing after the original trust maker passes away, that the descendants still have their share protected. And so the marital trust and the family trust kind of enable all of this, and so that's why we see that in revocable living trusts. But again, it's not just a matter of, the trustee passed away, or the trust maker passed away, and now I'm the spouse and I get everything, so I don't have to do anything. That is not accurate. There is some things to be done, and you do need to kind of review your trust and see if you've got a setup like this in there that needs to be respected. So if we can have, be of any assistance to you, if you want to have a conversation about either planning or administering a trust like this, we're happy to have that conversation for anybody who is in the Denver area of Colorado especially. So we are the McKenzie Law Firm, and again, our phone number is 303-578-2745, and thanks for watching this video. I hope this was helpful.